So good morning, everyone. It's really lovely to be here. Thank you for joining me for this webinar. My name is Coral Putrell, and I'm an Associate Solicitor in the Education team here at Forbes. So as the title suggests, I'm going to be speaking with you this morning about commercial contracts and the important provisions for you to be aware of when your school is entering into them. I just need to start with a little bit of housekeeping. So this session will be recorded and the slides will be shared with you after the session. Hopefully you'll have some questions as we go through. Please do feel free to pop those questions in the chat and I'll make sure that we either pick them up as we go along or I'll pick them up at the end. So that's the housekeeping all done. So I'll crack on. If we could move on to the next slide, please. So we regularly advise schools and colleges when they are entering into their day-to-day commercial contracts. So these traditional day-to-day contracts might be, for example, contracts for catering or cleaning services, security services, or perhaps photocopying contracts, for example. As well as those more traditional commercial contracts, we are finding more often that schools are entering into, for example, hire facilities agreements. So they might be entering into hire facilities agreements to, for example, hire sports hall facilities, or it might be a theatre space to improve and expand streams of revenue and just boost that money coming in. Also, you may have seen more schools, be it maintained schools, academies, or independent schools, they're choosing to enter into collaboration agreements to support each other in key areas. So regardless of the nature of your commercial contracts, whether they're your day-to-day contracts for services, or your hire facilities agreements or collaboration agreements, if you have them, there are certain key provisions which we advise schools to check to ensure that your position is best protected throughout the life of the contract. So let's get started on discussing what those key provisions are. If we could move on to the next slide, please. So I'm going to start with a few of the key terms, which are standard key terms which should be agreed between parties at the outset of the relationship. I think it's just the next slide that we need. Lovely. So these key terms, they cover the core of the agreement. So we're thinking about who the parties to the agreement are going to be, how long the agreement will last for, and importantly, what will be paid pursuant to the agreement. So looking first at the parties, when it comes to agreeing the party names who are going to be inserted into the agreement, you'd be forgiven for thinking that this is a wholly straightforward consideration. It's barely worth a second thought. For example, if your school wants to contract a cleaning company to provide cleaning services to the school, you'd expect the parties to be the cleaning company and the school. However, you should consider if, for example, your school has created a subsidiary for trading purposes. So, for example, we often see this where schools have a sports facility that they hire out for public use. It's common for those schools to create a trading subsidiary for those purposes. And in those cases, they may want the trading subsidiary rather than the school to enter into certain commercial contracts to ring-fence any risk away from the school. So it's always important, whilst it may seem like a really simple consideration, just make sure that the correct parties are entering into the agreement. The second of those core provisions, which I wanted to cover, is the term of the agreement, being how long the agreement will last for. It needs to be really carefully considered, and it again sounds very simple, but all too often we see contracts with no specified term at all. So we would expect your school's commercial contracts to specify a commencement date, and that's the date on which the parties' obligations will actually commence. For example, just to put it into context, If you wanted a catering agreement, for example, to take effect from the commencement of the next academic year, the commencement date would reflect that. Without a commencement clause, the parties must start performing their obligations when the contract is made or is otherwise specified. If other terms say when performance is to begin, a commencement clause may add nothing or could create confusion. So if you have a commencement clause in your contract, just have a look through, make sure there's no other clause which specifies when performance will be that would sort of contradict the commencement clause. Just make sure it all ties in together and is as you would want it to be. Keep in mind that a commencement provision doesn't dictate when the contract becomes binding. A contract is binding when it's made, even before it requires the parties to do anything. So, for example, if today you signed an agreement with a cleaning services provider, the contract is binding from today. However, you could have a commencement date from the 1st of September, meaning that services need to be provided from the 1st of September. It's a bit of a nuance, but just be conscious that commencement date and the date of the contract are two separate things. The contract should then also usually include perhaps an agreed minimum term or a fixed term for clarity. So, for example, this could be for a term of 3 years. The length of the contract term will vary according to the nature of the agreement. So what's appropriate for a one-off service wouldn't likely be the same as for a complex outsourcing agreement, for example. In some cases, it might be preferable for the school to have a shorter initial term for the agreement, with maybe an option to renew the term. That can be a particularly helpful tool if, for instance, you are unfamiliar with the other party and don't want to commit to a significant period until you get to know the services that they provide and you're sure that you're happy with them. So I've mentioned there you might have the option to renew the term. So one thing to consider is whether to make the contract renewable, and if so, whether it will be renewable on the same terms, so the contract just repeats itself, or whether you'd like the option for the parties to revisit the terms and maybe tweak them. So just keep that in mind when you're looking at the term or the length of the contract. The last of these core provisions is pricing. This is obviously key, and it's absolutely vital that the contract clearly states what's to be paid, when it's to be paid, who it's to be paid to, and also any interest or other consequence of non-payment. So the agreement should set out clearly the price, or it could set out a method for calculating the price. Failure to ensure that payment provisions are properly drafted can lead to dispute and risk a party not being paid or making payment as they had expected. If the price or the method of calculating it is not fixed expressly or impliedly in the contract, there is an implied term that the person receiving services will pay a reasonable sum for the services. That might differ from what you'd expected, so just make sure that your contracts are really clear about who is being paid, when they're being paid, and what they're being paid. I just also wanted to flag that VAT will be treated as included in the price unless the contract provides otherwise. So a supplier will usually want to make clear in the agreement that all prices are exclusive of VAT, just for clarity. So those are the three of the core terms that make up the core of the agreement. If we move on to the next slide, I'm just going to move on to endeavour clauses. Now, these are clauses which are scattered throughout a commercial agreement, but I'm not expecting you to be familiar with the ins and outs of them. The starting point is that contractual obligations are normally absolute, and failure by a party to satisfy an obligation is a breach of contract. Endeavours clauses step in and slightly nuance this position, and they're used when a party is only prepared to try to fulfil an obligation rather than to commit to it absolutely. Now, there's a spectrum of endeavours clauses. We most frequently see best endeavours and reasonable endeavours being used in commercial contracts, so I'm going to focus on those two this morning. If we could move on to the next slide, we're going to start with best endeavours. So looking first at best endeavours, this means that a party will be expected to take all those reasonable steps in their power which are capable of producing the desired results, being steps which a prudent, determined, and reasonable obligee acting in its own interests and desiring to achieve that result would take. Whilst this is clearly onerous, it's not an absolute obligation, nor is it the next best thing to an absolute obligation or a guarantee. One key feature is the reference to reasonableness, such as the requirement that best endeavours must at least be doing all that reasonable persons reasonably could do in the circumstances. So if you see this in a contract and a supplier has to use their best endeavours, the supplier may be required to expend money and they may need to sacrifice their commercial interests in order to perform their obligation. Alternatively, if the school has to use best endeavours, the school might be expected to incur expenses and sacrifice its own interests in order to meet its obligation. Helpfully, and I think interestingly, the courts have suggested that there are two ways in which a party to a contract could breach an obligation to use their best endeavours. One way that they could breach it is if they have not been genuine in their efforts to achieve the required objective. And the other way in which they might breach an obligation to use best endeavours is if, even if acting in good faith, they had failed to do everything that they reasonably could. So I think that sets a helpful line in the sand as to what is expected of you if you're subject to a best endeavours clause, or what the other party is expected to do if they are subject to a best endeavours clause. Now, reasonable endeavours are less burdensome than best endeavours. The concept of a reasonable endeavour is what would a reasonable and prudent person acting properly in their own commercial interest and applying their minds to their contractual obligation have done to try to achieve the objective. So if reasonable endeavours apply, a party might only be required to take one reasonable course of action. And once they can't do anything more in terms of reasonable steps to achieve the objective, it is no longer obliged to try to meet its obligation. So, for example, if a reasonable endeavours clause applies to a supplier to the school, the supplier would not usually be required to sacrifice its own commercial interests, and it may be entitled to consider the impact of its own profitability when reaching its obligations. That's one of the major differences between a reasonable and best endeavours obligation. So if you're looking at your commercial contract and you see that the school will use its best endeavours to do something, what we recommend is that you seek to have this reduced down to the more limited reasonable endeavours expectation. That will mean that you can take your own commercial interests into account when seeking to comply with your obligations, and it's just a less onerous obligation on the school. Alternatively, if it's really important to you and you want the supplier, for example, of a contract to have to take steps to achieve its obligations, you may want to seek to enforce a best endeavours clause, requiring the supplier to take best endeavours to achieve their obligation. So if we could move on to the next slide, please. I'm going to look at liability. So liability clauses within your school's commercial contracts are vital, as a well-drafted liability clause can help to protect your school's position if things don't quite go as expected. Limits on liability are among the most common and heavily negotiated clauses in a commercial contract. A limitation of liability clause can limit the risk of most claims made by a party against another party, Or in some cases, it can limit the risk of claims involving a non-party, such as an agent or a subcontractor. In the context of schools, for example, if your school is providing services pursuant to the contract, we'd expect for liability provisions to limit the school's liability to the other party. Alternatively, where your school is the recipient of services, the supplier is likely to insist on limiting liability as the service provider. You should therefore be seeking to ensure in these situations that the liability clause, which is likely to include a limit on the supplier's liability, is acceptable to you as a school. So we've spoken there about limiting liability. There are a few ways that you could do that. So for example, a liability clause can identify which liabilities are excluded. So a supplier, for example, may exclude specific losses, whilst a customer may prefer not to propose that any risks should be completely excluded. Alternatively, liability might be capped, so that would mean that the contract may cap liability to commonly, we might cap it to the value of a contract in that year, or the value of a total contract, or a percentage of a total contract value. It could be alternatively that liabilities are unlimited, meaning that a party might accept unlimited liability for specific liabilities. When we're looking at liability, insurance often comes into the conversation again. For example, the parties to a commercial contract might agree that the party which is liable must insure against the risk, just as a bit of added security to make sure that there will be a source of funds to pay any liabilities. Keep in mind that this is likely to lead to some negotiation because a party which needs to rely on its insurance to pay a claim is likely to want to exclude liability for any losses which it's not insured against. So we'd expect for them to be seeking for any exclusions to match exclusions in their insurance policy. We'd also expect the liability provisions to include an agreed time limit for any claims, and we'd expect that time limit to align with the time frame within which the insurer would need to be notified of a claim. It's also important to keep in mind that not all liabilities can be excluded, and wording that purports to do so is void and unenforceable. So, for example, fraud, liability for death or injury caused by negligence, they cannot be excluded, and a clause trying to do so will be void. I just also wanted to flag, whilst we're looking at liability, penalty clauses. So these make a certain amount payable for breach of contract. When a certain amount is payable for breach, the amount should not be excessive. Otherwise, it may be considered to be extravagant and unconscionable and deemed void. So if you see these sorts of provisions in your contract, so for example, we might see it in a photocopying contract, seek legal advice. Now there are clauses called liquidated damages clauses which set a fixed or determined sum, but that's agreed by the parties and it's payable on breach by one of the parties, and it's a reasonable assessment of loss which has been agreed between the parties, so it's separate from a penalty clause. If you see a clause in there which just says a fixed sum that you've not agreed and it seems excessive, get legal advice because it might be a penalty clause and it might be void. So if we could move on to the next slide, please. I'm just going to move on to boilerplate clauses, and some people call these the boring clauses, which are often in the small print at the end of a contract. They are the terms which we use most often, but they are all too often ignored. They are repeated in all kinds of contracts, and they're often standard and not heavily negotiated, but they are important. Most are not the commercial terms that vary from one transaction to the other, but they regulate the contract's operation, meaning, for example, its interpretation, whether the contract can be transferred, and the enforceability of the contract. So they are small but mighty. So if we could move on to the next slide, please. So starting with entire agreement clauses. The entire agreement clause is an important boilerplate clause in a commercial contract and has been a frequent subject of litigation. Entire agreement clauses are intended to prevent the parties to a written agreement from raising claims that statements made during contract negotiations, which aren't included in the final agreement, constitute additional terms of the agreement or some kind of side agreement. So, for example, it could be that before entering into a contract with a cleaning services provider, you've had conversations and mulled thoughts over, but those thoughts and conversations haven't made it into the actual agreement. At a minimum, we advise schools to ensure that contracts include a statement that the parties have agreed that the terms of the contract between them are to be found in the contract and nowhere else. So that would mean that those pre-contractual discussions, those thoughts, that mulling over, do not form part of the terms of the contract. Keep in mind, if you have any agreements with parents, entire agreement clauses are at risk of being found to be unfair and unenforceable. This is because consumers, such as parents, commonly and naturally rely on what is said to them when they are entering into a contract. So just be conscious if it is an agreement with a parent that you're entering into. Be conscious of the conversations that you're having before entering into that contract, because an entire agreement clause might not be enforceable. Most entire agreement clauses also include clauses relating to misrepresentation. So that could be an acknowledgement by the parties that they have not relied on any representation not set out in the contract. And that's just a little added step to prevent claims and misrepresentation relating to any pre-contractual statements. So looking at interpretation now. Interpretation provisions can cause real problems and real headaches. We have seen on many an occasion cut and paste contracts which contain, for example, two definitions for one word, which is clearly not helpful. Alternatively, we've seen that the meaning of a word used in the contract is not clear, which can then lead to disputes. So just to put this into context, we might often see references to days throughout contracts. Without a clear definition, the parties may differ as to what they interpret a day to be. So one might consider it to be a calendar day, whilst the other party may consider that it means a business day. And that can seem like a really small issue, but it can snowball and can often lead to disputes. So it's really important to check these interpretation clauses in your contracts. They confirm, modify, or create rules of contract interpretation. So if you have any queries, just seek legal advice and make sure that they're really clear. I also wanted to look at variation. So as you'll be aware, over time, a contract may no longer be entirely appropriate, and changes to some of the terms might need to be made. It can, of course, be helpful to be able to vary the contract during the term, and most commercial contracts can be varied or novated in English law without writing or signature. However, we would expect your commercial contracts to include an express variation clause, requiring variations to follow an agreed procedure. So that could be requiring that the contract is varied by written agreement of both parties and making a non-compliant variation ineffective. So what this means is that you can be assured that the other party to your contract is not going to vary it without your written agreement. I also wanted to touch briefly on another boilerplate clause, which is assignment. So contractual rights are freely assignable in English law without the other party's consent, and also subcontracting is not generally restricted. If it's important to you that only the original parties can perform and demand performance, you will need express terms setting out that the agreement cannot be assigned without written consent. So that finishes those boilerplate clauses. As I say, they do crop up in every commercial contract. They do seem very small, but the impact of them can be significant. So just make sure to have a read through them and make sure that it's all as you'd expect and want. So if we move on to the next slide, we're going to be looking at force majeure. And this is a clause which has received a lot of coverage in the past few years. Force majeure provisions are used to excuse one or both parties from performance of the contract where certain events outside of the parties' control occur. And I expect you won't be surprised to hear that force majeure clauses really came into their own and took the spotlight during the COVID pandemic. So if we move on to the next slide. So the effect of a force majeure clause is that a party to an agreement with an effective force majeure clause will not be liable for its failure to perform its obligations. It's used in contracts because there are limited remedies available to parties under English common law where a contract becomes impossible to perform. And we really recommend that your school's contracts include a robust force majeure clause. When we're preparing them, they tend to be about a page long just to make sure that they're robust and cover all eventualities. So I've thrown the word force majeure around there quite a bit. It doesn't actually have a recognised meaning in English common law, and instead its meaning in a contract will be a question of interpretation. Therefore, to avoid uncertainty, it must be properly defined within the agreement. For example, a clause which states that the usual force majeure clauses will apply will be void for uncertainty because what are the usual force majeure clauses? We also want to flag to you that your force majeure clause must also comprehensively list situations which you consider may occur. Just by way of example, these commonly include pandemic, flooding, and industrial action. So those are those clauses outside of a party's control that may impact performance of obligations under a contract. For the most part, force majeure clauses are suspensory, so that means that the affected contractual obligations don't go away entirely. They will be suspended whilst the force majeure event continues. So, for example, if flooding impacts the ability to perform obligations, the obligations will be suspended until the flooding subsides and it's possible to continue to perform obligations. When the event comes to an end, the contract will be reactivated. Once the force majeure clause is effectively triggered, it generally provides that the non-performing party's liability for non-performance or for delay in performance is removed, and that's usually for as long as the force majeure event continues. Now, many force majeure clauses go no further than to suspend the party's obligations for so long as the force majeure event continues. However, in some cases, it may be that it becomes commercially unfeasible for the parties to resume performance of the agreement, even once the force majeure event has ceased. It can therefore sometimes be preferable to allow either or both parties to serve notice of termination after a specified period so that alternative arrangements can be made. For example, if after a period of 12 weeks the event is still continuing, it might be preferable for both parties to be able to bring the agreement to an end and move forward. So when preparing a force majeure clause in your commercial agreements, we recommend that you consider how long the period of suspension of obligations should last before the right to terminate the agreement in its entirety arises, and particularly where both the affected party and the unaffected party have the right to terminate. The appropriate period will depend on the nature of your obligations, your relationship, so give this some thought. It will be a consideration for you to make and will depend on your relationship with the other party. When a party is seeking to rely on a force majeure clause, if, for example, you as a school can't perform your obligations because of a force majeure event, the burden of proof is on that party seeking to rely on the force majeure clause. So that party must prove that the alleged force majeure event falls within the clause in the contract and that non-performance of their obligations was because of the event. Also keep in mind that a force majeure clause usually requires the defaulting party to show that it used its reasonable endeavours to prevent or at least to mitigate the effects of the force majeure event. Even where there's no such express requirement stated within the commercial agreement, one can be implied, so just be conscious of this. Also, a force majeure clause will often make the affected party's reliance on it conditional on it giving notice of the event to the other party. So going back to an example, if flooding has affected a party's ability to comply with its obligations, it's likely going to need to provide notice to the other party that flooding has impacted its ability to perform those obligations. Sometimes there won't be a requirement for notice, and the protections of the force majeure clause will be automatically available to the non-performing party when the event occurs. However, it's usually sensible to give notice of the force majeure event in any case, just to make sure that all your bows are tied and your I's are dotted. So we recommend including notice provisions in your force majeure clauses just to ensure clarity. So that's force majeure. If we move on to the next slide, please, I'm just going to look at termination. So termination, it's another vital provision, which again, as so many of these terms do, it seems obvious, but we all too often see either termination clauses not being implemented in an agreement properly, or not having been included in the agreement at all. So when we're talking about termination provisions, these are effectively the rights of a party or both parties to bring the commercial agreement to an end. And they are critical to a commercial agreement, but unfortunately, as I said, all too often we see contracts which either make it really onerous for the school to terminate the contract, or in some cases don't contain termination provisions at all. If we can move on to the next slide, please. As a starting point, there is always a common law right to terminate for very serious breaches of the contract. However, our recommendation is that you don't want to have to seek to rely on this or to prove this point. As a minimum, we would expect your school's commercial contracts to allow for termination by the school where there has been a material breach of the contract, meaning that you may terminate the agreement with immediate effect where the breach by the other party, for example, reduces the value of the contract to you. We'd also expect you to be able to terminate where there are repeated breaches of the contract, meaning that you can terminate the contract for breaches that have been so numerous that you can have lost confidence in the contract. This is often needed, for example, to bring the agreement to an end where there have been a number of irritating problems with performance of the contract, rather than a really core substantive breach. Of course, a party can't normally terminate an agreement on the grounds of its own breach of contract, even if the contract appears to give it that right. The common law principle is that a party can't take advantage of its own wrong. So if you're in a position where the other side to one of your contracts says there's been this breach, we caused the breach, but the contract seems to give us a right to terminate because of that, seek legal advice because that's unlikely to be the case. Now, as well as this, the optimum position, which we would always seek to include for schools, as well as termination for material and repeated breaches, is for you to be able to terminate the agreement for convenience. So we always advise schools to ensure that they have the option to terminate the agreement without cause, meaning that there does not need to have been a breach or repeated breaches by the other party at all. And you'd just be able to bring the contract to an end because you want to on notice of, for example, 3 months, and this can save a lot of disputes. We also recommend that the contract should set out the parties' respective obligations on termination of the contract. So, for example, some provisions that we might expect to see would be for the supplier of a service to submit its final invoice for payment and for the parties to return any equipment they may have, or to deliver up or destroy any confidential information relating to the other party that they may have. In more complex arrangements, so we're thinking here perhaps agreements for IT services, contracts may contain provisions obliging the supplier of these services to assist in the seamless migration of the provision of services to a replacement supplier, so as not to leave the school in a position where it doesn't have any IT services until it's been able to find a replacement. When it comes to looking to terminate a contract and to enforce those termination obligations, we recommend that you consider the practical implications of doing so. So, are transitional arrangements required? Will you need another provider? How soon might you need it? How soon can you achieve it? Think about the effect of termination on any equipment, such as photocopiers. Think of any duties that might arise on termination. If it's going to be necessary to make an immediate payment, consider whether you're in a position to be able to do that. And think about any contractual duties that survive termination. So typical examples of duties that would survive even once a contract's been terminated might include confidentiality obligations. So just be conscious of those considerations if you're considering terminating an agreement, and make sure you're comfortable with those. So I'm just going to now move on to notice. If we could just move on to the next slide, please. I think we might need one more. So whilst giving notice, for example, to terminate a contract, that might seem simple. It's key to ensure that notice provisions are really well drafted, as failure to do so might mean that notice will be ineffective. If followed closely, a notice clause can prevent argument over whether service has been achieved and increase certainty for all the parties. If a notice clause is overlooked or ignored, any notice can provide grounds for disputing the validity of notice that did in fact reach the other party's attention. So without a notices clause, parties can serve notices provided where statute permits, such as service of notice by post or hand delivery in some situations, including documents served on a company registered in England or Wales. If statutory methods don't apply, common law generally allows service by any method that brings the notice to the attention of someone authorised to accept its delivery. So when we're looking at your school's commercial contracts, as a minimum, we'd expect for your contracts to include a notice clause specifying how notice should be given and when it's deemed to have been received. It's also important to specify within the notice clause that notice should be written and can't therefore be given during casual conversation between parties. We'd also hope for you to specify whether email will be accepted and when notice is deemed to be delivered. For example, the usual position is that notice delivered by recorded delivery is deemed delivered on the second working day after postage. Where precise timing matters, for example, if you're giving 3 months' notice to terminate the agreement, you need to make sure that that notice is given within those 3 months. Precise timing may matter to make sure that service doesn't take place outside business hours. So the clause may also specify a time of service, and that can be particularly important to maybe align with your school hours. So including this clarity in notice provisions in your school's commercial contracts can help to ensure parties know how and when to provide notice, as well as ensuring that this key information is included in notice provisions. Keep in mind if you're entering into a contract which is one of several relating to a matter, ensure that those notice clauses in each of those documents are consistent and don't conflict with one another. So that brings notices to an end. I can see that we do have a question in the chat, so let me just take a look at that. So somebody has asked if I were due to start a contract on 1st of April, what was agreed by the supplier was not fulfilled, but they still expected the school to commence with them on the above date. Confirmed that we would not be changing in early Feb, so was told that we were bound by the contract. Could I state best endeavours for this? It will depend on what your agreement says. So when it comes to endeavours clauses, if you wanted to rely on best endeavours, so for the other side to have used best endeavours to fulfil their obligation, the contract would need to state that the relevant party needs to use their best endeavours. So check the terms of your agreement, see if best endeavours is applicable. It will ultimately depend on the wording of your agreement. Feel free, if you want any advice on that specific matter, feel free to get in touch and we can have a look at it and let you know what your best options are. Were there any other questions? Feel free to pop them in the chat if so. We finished a bit early, so I'm happy to wait and see if there are any questions. I'll give you a minute or two to pop any into the chat. And if not, I'll give you some of your time back today. So we've had a question, when is a time of essence clause relevant? So a time is of the essence clause. We often see these where there are payment obligations. So it may, for example, say time is of the essence when it comes to making payment under, for example, a services contract. Time of the essence, what that means in practice is that if the other party to the contract has an obligation to make payment and time is of the essence for payment, what it means is that if payment is not made in a timely manner in accordance with the terms of the agreement, that could constitute a material breach. So time of the essence clauses, it's basically an indicator that failure to comply with that time frame, that relevant time frame for that clause, will constitute a material breach. So if your school is under an obligation to perform something and time is of the essence, make sure to comply with that timescale because it may constitute a material breach of the agreement if you fail to do so. So that's how they fall into practice in your commercial agreements. So I think that was all of the questions. I hope you found this session helpful. If you do have any follow-up questions, feel free to get in touch. If we move on to the next slide, my email details are just there for you. Feel free to drop me an email if you have any queries, anything you just wanted to double check, and I'd be happy to have a conversation with you. But otherwise, thank you ever so much for your time, for your questions, and I hope you have a lovely rest of the day.